So the ANC and the UDM are winners here, and the DA is planning to take the matter to court. But will all of this have an impact on when the elections finally take place? Let's chat to public law professor Jaap de Visser for more on this developing story. Professor, thank you so much for joining us. So this decision by the IEC to reopen the candidate list, is this a welcome and necessary move, or is it a dangerous precedent?
Good morning. Yeah, what the IEC has done, it has basically applied a normal electoral logic, which is that the voters' roll closes, and then whoever is on the voters' roll can be nominated as a candidate by political parties. Now, the voters' roll had been closed, and the Constitutional Court essentially gave a window to reopen that voters' roll. So in that logic, it follows that if there's new voters being added to the voters' roll, that there then also is an opportunity for political parties to nominate candidates following that. That is a normal electoral logic. However, legally it is more complicated because the Constitutional Court order and the Constitutional Court process seems to have pointed in the other direction. The Constitutional Court essentially gave a window to reopen the voters' roll and add more voters to the voters' roll. But the issue of opening also the possibility for parties to nominate candidates was before the court. The EFF asked for it. In court, the IEC argued against it and said, we don't want to do that. The Constitutional Court then decided, let's not do it, and let's not grant the EFF its prayer to reopen the possibility for nomination of candidates. But now the IEC is coming out and making it possible once again. So there are two possible interpretations. It's normal electoral logic that it's going the way the IEC is now saying, but there are, I think, some legal questions as to how they are interpreting the court order.
Well, the opening of the candidate registration list is part of the election timetable, right, Prof? And the Constitutional Court said that the IEC could change the timetable if they found that it was necessary. So do you think that the normal flow of election processes is a necessary reason to change the timetable?
Well, as I said, it follows the normal electoral logic, because if you just imagine that there are now new voters being added to the voters' roll that were not there before, so they can now also technically be nominated as candidates by political parties because they are now part of the voters' roll. So it follows the normal logic, but I think many lawyers, including myself, we do have questions as to how far the IEC is stretching the meaning of what is necessary. You know, what the court said you can do what is necessary. And is this necessary given the fact that it had been canvassed in front of the Constitutional Court and the Constitutional Court said no to that option?
So in your opinion, does the DA have a case here if they do decide to challenge this IEC decision in court?
I think it also depends a bit on the judgment. Remember, we're all working from a court order. It's just the 2 pages of what the court actually decided. We don't have the judgment. I think once we have the text of the judgment of the Constitutional Court, we will have much greater insight into what exactly the Constitutional Court's reasoning is. And then it will be much better able to answer that question. But it is a pity that we are now entering into, what can be called lawfare, that the election is now essentially being determined by court cases and court action litigation. It's not good for the credibility of the electoral process. It's a pity that we ending up in this phase of court action. But from the DA's point of view, I can imagine, political parties will always follow the IEC very closely, and the IEC has to follow procedure to the letter. And if anything goes astray, then political parties will vehemently object to that and take the IEC to court. That's the nature of the game.
Professor, very quickly, how does this situation we're in now differ from that 2016 case of the National Freedom Party, where they wanted the candidates list to be reopened, but they were denied?
I think that was more of a straightforward case of a political party not meeting the determined deadline without any opportunity later for it to be opened again. The Constitutional Court has responded to an application to reopen the voters' roll. But remember, the voters' roll is too narrow. We have far too few voters on the voters' roll. So there's a good case for the voters' roll to be opened. And opening the voters' roll does also open the possibility of candidate registration. So it's slightly different, but I think that the bigger point is rules are rules, and the IEC must stick to the rules and be very closely followed by all political parties.
All right, Professor, thank you so much for that viewpoint. We appreciate it. Elections analyst, Professor Jaap de Visser, thank you for your time this morning.